Welcome to the Downtown Den for this special podcast that we're recording to talk all things employment law, and obviously lots of changes on the horizon as far as that is concerned. And I've just listened to a fascinating peopleHUB podcast that was delivered by our good friends and partners at High Performance Consultancy and oneHR. So I'm delighted to be joined by Claire McGuinness, who's Head of Operations for High Performance Consultancy, and Victoria Brown, the Managing Director of oneHR. Now, just for context, these changes obviously have been mooted for about 12 months now since the new Labour government was elected, but there is further confusion, perhaps is the word, as to how many of these changes will now go ahead, because of course the Deputy Prime Minister Angela Rayner has resigned, being replaced by people who are seen as perhaps a little more sympathetic to the business community as far as employment law is concerned. However, I think that we should take it that the changes that have been proposed and are currently in the Lords being scrutinised are those that we have to deal with, and then if changes come subsequently, then we can get you guys back on and we can talk about those amendments. But let's assume that the Employment Rights Bill will get royal assent and go ahead. Now, Claire, you spoke for an hour, and I guess could have spoke for 2 hours, because they are wide-ranging, the changes that we're looking at here. Can I just pick out some highlights that I think will be of particular interest to the Downtown network, and then obviously you can pick up some of the things that you think are of particular importance. But from October 2026, run me through this dismiss and rehire change that is likely to happen.
So what this means, Frank, is at the moment where, I mean, I know everybody kind of relates to the P&O case, don't they, with this, with the fire and rehire, and that it was so frowned upon of the way it was handled. And I know trade unions have been kind of obviously championed for this for a long time, for it to become unlawful for employers to action dismissals this way. So at the moment, for employers to change employees' contracts in terms of pay, pensions, holidays, those the main statutory entitlements, you have to have agreements from the employee, and you know, employers can't unilaterally make that decision to just make those changes without agreement or vary them. And what that will mean is that without that proper consultation, and what appears to be the only caveat to being able to fire and rehire is if your business is about to go pop, on the basis of that. And, you know, I know that some small businesses will be inclined to use that. It might be genuine. But what will happen is that your business will be closely scrutinised at a tribunal for your reasons for ending that contract, because it will be unlawful to do so. So it's pretty powerful, I'd say.
Just going back onto that, well, the comparison you made there in terms, or the example you gave there in terms of P&O, I think, Victoria, that we'd all accept that that was an unacceptable way of firing people. Do you see any potential dangers for people who are trying to do the right thing as far as dismiss and rehire is concerned, or is this legislation that you think overall needs to be introduced?
I think, to be honest, when we look at a lot of the Employment Rights Bill, and I do in essence believe in the spirit of it, you know, in terms of we need to modernise the way in which we look at employment law and workers, and we need to be fair and equitable. But this is a great example of, we've looked at something that I thought was atrocious, you know, P&O behaved in a very unfair way. And from my experience, and we've worked with thousands of clients, not many clients would ever use, this is a last resort for them to use. However, it's like anything that we're looking at in the Employment Rights Bill at the moment. It just doesn't, some of it doesn't feel practical, and it's not considering in pro-business to consider, you know, if we're saying it's a last resort now, as in your business is about to go pop, there's changes that need to be made sometimes within an organisation that are really old-fashioned ways. You know, we had ones who had some really, really old-fashioned ways of working around shifts, around their sickness processes, which were great at a time where they were a highly profitable organisation. But times have moved on. You know, they've had to try and adapt, and they had to enter into these sorts of consultations, but they did have in their back pocket a last resort would be that they could fire and rehire, and they were very fair now where that would be unlawful. They were about to go into administration, but had they not been able to push through those changes, then 2 years down the line they would have been. So it's like a lot of the concerns I've got around the Employment Rights Bill suggestions. I'm not sure a lot of thought and process has gone into some of these changes, and it's trying to obviously protect workers, understandably, because of the likes of P&O, but we're not considering these situations where we might actually reduce the agility for business owners to be able to make some decisions to prevent job losses in the future.
I think it's the unintended consequences that you highlight in there. You know, the government have put this legislation forward on the basis of it being for the right reasons, but as you rightly point out, there are some businesses that want to make those changes as necessary to keep their business going in a modernising way, and they're going to be caught up in this, and you don't really want to be getting to the 11th hour before you can make those changes, and the businesses basically bust. So that's one to keep our eye on, and obviously we are, as an organisation, lobbying MPs hard to try and at least dilute some of these proposed changes. But let's move on, Claire, to another one. I think, again, you can see why the government will be looking to strengthen this piece of legislation, but as I say, some unintended consequences potentially as well, and that's around harassment.
Yeah, I mean, in terms of the third party harassment,
yeah,
you know, it's one of those things that it came out last year where employers had to take reasonable steps to show that they taken all reasonable steps and actions to prevent sexual harassment. And to be honest, I feel like it's taken majority of businesses to grasp what it really means, even if we are saying, here's your policy, this is what it's supposed to look like, this is what you need to do to show that you are got reasonable steps in place to prevent it, or what are your actions going to be if this was to happen. And a lot of businesses think, well, I'm doing everything that I can already, what are the steps? And the steps are simple. They are a risk assessment, you know, educate your teams on what to do if there's a complaint made, what does that process look like? And now it's kind of gone into the whistleblowing aspect as well. It's going to be even more prominent, I think, than it already is, in terms of if some employees are sexually harassed and they do blow the whistle before, now that, you know, that's protected now. So when it comes into October 26 and 27, when, you know, the screws turned a little bit further on that, reasonable steps, to say all reasonable steps, and it is a little bit unclear as to what that looks like. What is the difference between reasonable steps and all reasonable steps? So because we don't know yet, it's putting everyone in a position to say, well, what else do you want me to do? I've done those things you asked me to do last year, putting them in practice, I've got them in writing, training my teams, I've took all reasonable steps already. I haven't left some out to say I won't be reasonable with some of them. I'll just save some of them and you know, be less reasonable. There's so much confusion around it. So I think until it actually comes out as part of if it's passed within the bill, and later on, because it's so staggered, we essentially may not even know until 2027 what those all steps mean. My guess is it's just tightened in terms of, yes, you're saying you've got it, prove it. And, you know, what does it look like?
Again, I think this is something, Victoria, that the last government looked at, and they did sort of water down this piece of legislation for the very reasons that Claire has outlined there. You could see an awful lot of companies going to tribunal and saying, well, we feel as though we did take reasonable steps. It's a very subjective phrase, that, isn't it? And that's where you start to get grey areas of the law, which in essence don't help anybody.
No, and that, as you've just pointed out, Frank, that it was a significant change that the previous administration made, by removing that all reasonable steps, just slightly diluted. And obviously every organisation, every business now has that responsibility and do need to make steps, and it's absolutely a step in the right direction and where we need to be. However, we need those clear parameters of now, if Labour have decided to add in all reasonable steps now into that bill, what does that look like? And it's like anything, as you say, there is always room for I always say to all of our clients, the only people that really make the money in this is the lawyers and the tribunal system, and that sort of links back to my concerns I've got. There is not enough money being pumped into the employment tribunal system. So when we've talked about a lot of these changes, and we're unclear, for example, on what those parameters are for all sorts of reasonable steps, it will open the floodgates to the tribunal system that is already saturated. We've already getting sort of listed for tribunal claims 12-18 months in advance. How they anticipate and that just feel like they're ill prepared for these changes, and there's no ability in that process at the moment. ACAS don't have the ability to do so. The tribunal system hasn't got the resource to sieve out some of these spurious claims as well, because you can imagine, by not having clear parameters or having parameters in place, until you get to that day and you are in the tribunal, that it may not be thrown out beforehand if it's a spurious claim. And what you've got to consider for an employer in that situation is they've got to defend that beforehand. And you are looking for a lot of our clients over the years, you're spending sort of £9,000-10,000 just to get to that, to see that judge on that day, for it to be thrown out, which doesn't feel pro-business, as Labour have said an employment rights bill is.
Yeah, okay. I just want to turn my attention now to something that I think will obviously impact on many of our members in hospitality, and that's tipping. Just wondered if you could run us through that change, Claire?
Yeah, sure. So that change is, it's not huge. I mean, I think when the whole tipping changes came in and the policies and for those sectors that are, obviously using the tipping system, and I think it was a lot for businesses to get their head around initially, but I think they've got there now. So the only changes to that is that employers have to give their staff the right to consult, if you like, on a new policy. So if they're implementing or making any changes to those tipping policies, I don't expect it will mean we have to get agreement from every single person, but some kind of collective agreement on what that policy looks like. And just my guess is to make sure that there's nothing untoward getting slipped back in there, because tips used to be, a bone of contention, didn't they? Who was getting them, who was taking them home, and rightly so. So that, at least there's a proper process and procedure, and people know where they stand with it. So yeah, the changes for that is that they will need to have some involvement in the policy, and that businesses will need to renew them policies every 3 years. So not huge, but still to kind of keep in there to make sure that you're compliant.
Yeah.
Ultimately those types of things where people don't get the tips when they should be, they're the types of things they take to the Fair Work Agency and because they're annoyed about them, aren't they?
Yeah, absolutely. Right, and the last one, as far as October 2026 proposed changes is concerned, I wanted to touch upon is the employment tribunal time limits, Claire. So again, if you could run us through the proposed changes there.
Yeah, so at the moment, the the employment tribunal claims time period for an employee to make a claim is 3 months, and that is expected to change to 6 months. So, for example, where if you were to make some redundancies or generally dismiss someone for underperformance or whatever reason they've been dismissed, everybody has a right to appeal that dismissal, and everybody has the right to make a claim up to 3 months less 1 day, and that's now going to 6 months, so it's double the timescales. So if, for an example, we were making redundancies and we were looking to rehire again further down the line in 3 months, 4 months, 5 months, then there is some kind of potential consequences there for us if we were to backfill those positions within that 6 month period, because that claim period is still live for 6 months. So absolutely to be mindful of. And for employees, it's, you know, it gives them an additional 3 months to prepare their case.
Okay, and that's really going to help, isn't it, in terms of that tribunal's backlog that you spoke about, Vic?
Exactly. It's just not being thought through at all, you know, and I think everybody, obviously every employee has a right to a fair process, and if an employer, we need that system in place. But if we are to say, well, we're going to double the period of time now, I mean, I actually don't think that the 3 months is unreasonable now. It gives people plenty of time to be able to submit a claim. It's incredibly stressful for an employer to have sort of 6 months looming now, thinking that they're not sure if that employee is or isn't going to submit that claim. And again, just sort of reiterate what I said before. We go to conciliation. ACAS don't have powers to overrule anything. You know, spurious claims are not dismissed at that point. The tribunal system's got horrendous backlogs. It can be very costly because obviously during that time, if you haven't got insurance cover and your employer is relying on using an employment lawyer, for example, the longer that takes, you can imagine the back and forth in emails, the communication, all adds up. It's an hourly rate. It can be an incredibly costly time, but most importantly, a stressful time as well. And I think both Claire and I can speak from experience where we have supported, you know, a client, a business owner who has had terrible. The stress has really impacted on their life. You know, we're aware of divorces, we're aware of, you know, poor health, poor mental health, because it's just dragged on for such a long time, and that is down to a failing from the tribunal system, because there's just not enough resource, not enough money being pumped into that system. Yeah,
not fit for purpose, that's for sure. So there are some of the changes that are happening in October 2026, and then we move to 2027, and it will soon be here. I heard you say on the peopleHUB, Claire, that these things sometimes feel a long way away, but you need to start to prepare as soon as you possibly can. It's just two particular things I want to pick out from the proposed 27 changes, and the first is unfair dismissal day one right, which I think is the thing that is absolutely getting business owners wound up, because we do have these probationary periods in place for a reason. I always say this is not just sometimes for the employer, it's for the employee as well. You've got to see if the fit is right. But talk me through what this unfair dismissal from day one right means.
Yeah, I mean, really, it's just a game changer, isn't it, Frank, in terms of how businesses are going to operate. I mean, it will be huge at the time when it comes, and I think people are just sitting with the fingers crossed, thinking it won't happen. And I think it will. And just as we were talking before, just on the tribunals and the backlogs and the stress that they cause, this is going to be absolutely huge, because the government is anticipating that around 9 million people will have the right to claim unfair dismissal. So if that's 9 million people landing in a tribunal, who's funding the tribunal? When are they getting done? Not the government. So who is doing it and when? Does that mean you're going to now have a tribunal around your neck for 3 years rather than 2? So yeah, it's huge. And, you know, in terms of what employers need to do is, I'd just say prepare for it. Get the foundations set now. So what do your practices look like now? are you a business that does use that 2-year probation period quite a lot? And how do you recruit? Are you recruiting for bodies and arms and legs, or you just remove people because they're not working out? What does the onboarding process look like? Getting it right from the offset is going to be the main factor. So is that you don't have to use that 9-month probationary period to evidence on why somebody's not a good fit. And the you're not a good fit isn't going to wash anymore. We're going to have to be able to demonstrate why. And that's what's going to have to be in those performance one-to-ones. And yet they can be a lighter touch. Not saying you have to performance manage every employee within the first 9 months, but you are going to have to give a reason, and you're going to have to allow the employee to have a voice as to why they shouldn't be dismissed and why they, are sat in that meeting being terminated for reasons that you don't necessarily need to give, but then you will. You'll need to provide evidence of why. So yeah, a big impact in terms of costs as well, because of recruiting people. It costs to recruit, and then if people are say, we've just recruited somebody, it took us ages to find the right person, we've paid recruiters and all of that, we've got somebody and they don't fit, we're going to remove them. Well, you recruited them for a reason, so really delve into why do we need to remove this person, why aren't they a good fit, what are we doing wrong, could we do something that could help support them past that probation period and make it work, rather than the quicker option of removing. I think that will be a bigger factor.
Okay, cool. I do wonder what impact this is going to have in terms of hiring people. I wonder whether a lot of businesses are going to start to introduce things like temporary contracts and just to mitigate against the risk that this piece of legislation obviously sets up. And I think the other thing I'd say to the government as far as this is concerned is that if you're looking to grow your economy, then that's not necessarily the best change to make, because, as I say, we've seen from the national insurance increases that were introduced earlier this year that we've seen a slowing down of recruitment, and I can simply see that accelerating if this change does go through. Vic, any thoughts on this particular change?
Just to say, I reiterate, Frank, what you're saying. I really do think that this, amongst some of the other things we've discussed today, will stifle growth. All I ever hear at the moment, my daily grumble from employers, is national insurance increases and day one right, and this concern and this inflexibility and being overwhelmed by so many changes so quickly, where they will start to think, particularly small businesses, well, should I take somebody on, or actually should I look at how I can embrace AI further, or as you say, look at other ways to sort of to utilise resource without actually taking on staff, which just increases our unemployment rates. But what I fail to understand with this change is why it's so extreme. How can we go from 2 years at the moment to day one? Why are we not staggering this for business owners? Because arguably it's 2 years too long. And do some employers abuse this? Yeah, they do. And this is the problem. Like we mentioned P&O, Claire mentions Woolworths earlier around sort of redundancy consultations. It's the small minority of poor employers and bad behaviour that feels like every other business owner in the UK is being punished for. So I would really urge the government to just reconsider the period of time. Why can't we move to 1 year? We all know when we recruit, and we may try in the best will in the world and use recruitment agencies and use a thorough process to recruit, but you just never know, do you? And even sometimes in our 6-month probation period is not quite long enough, and we can get a curveball a little bit later on, which is going to just make it really, really difficult for employers. And just again, going back to the tribunal system, we're just not prepared. Really not prepared for these changes.
Okay, and the final one I want to talk about today, Claire, is 0 hours contracts. Again, something that is very contentious and not exclusively, but does impact, I guess, heavily on the hospitality sector. So if you could talk us through that, that'd be great.
Yeah, sure. You said that, Frank, like I had for the last 2 minutes, just to fill it with that. Like I need a day. Yeah, it's another big one, especially for the likes of hospitality and all of those kind of sectors that use the 0 hours and that they need the flexibility. And you know, I think what's to be remembered is employees want this flexibility as well. So if there's as long as there's agreements made there in terms of how these contracts are issued, the flexibility both sides, they can carry on and do that. What employers won't be able to do is, you know, not guarantee the hours, just be able to remove shifts. So it goes both ways. You know, some employees just don't turn up. It's so annoying. If the shift's guaranteed, it's guaranteed both ways. But you know, and for the employee to be penalised will be following their disciplinary process, whereas the employers being penalised will be there'll be a potential fine. So I think it's something that 0 hours is kind of outdated in its day. It's had such a bad reputation, and I genuinely feel like it's trying to be aligned with some structure and fairness for people, for those who do have unpredictable hours, are not guaranteed hours, do get called, cancelled last minute, don't get paid, got families and just lost a week's shift for no reason. And the same for the employer, where people just don't turn up because they've got a second job. So I think tightening up the actual the 0 hours, what's important to remember, it's the ban on being exploitive with the 0 hours contract, not a ban for being flexible. But yeah, I think it's gonna cause a lot of complexities. I think at the time when it comes round to people claiming that they should have guaranteed hours of what that looks like, and especially for hospitality rostering, it's already a minefield. Are they coming in? I don't know. Should they come in? Do they have to come in? What can I do if they don't come in? I think it potentially would give a little bit more structure both sides. If you've got your guaranteed hours, you're on your roster, and they're treated in a way as that we know they should be, which is fair. Like employees who are on full-time permanent contracts, they shouldn't be treated any different in that sense. So I think there's pros and cons for that one, really. But yeah, a bit of a minefield, and there is still some ironing out of that legislation yet.
Okay.
So
right. Well, it's all very simple, obviously, and nothing to worry about if you're a business owner. As I say, on a serious note, we just had a very detailed run through on your peopleHUB webinar. So we're going to put a link to that hub for people who are interested in hearing about these things and the many other changes that are proposed in the Employment Rights Bill. So you can go to that link, which is in the show notes, if you want to hear more. You can also contact High Performance Consultancy via Downtown in Business. So get in touch with us and we can introduce you to Claire. But we'll also put Claire's email address in the show notes as well, so you can contact her directly. The one thing I'd say to politicians, and as I say, we are lobbying hard to get some of these changes diluted. We understand and appreciate that changes need to be made, and indeed we support some of them. But I just remind them of the old saying that many people apply to politicians that drives me mad, and they're all the same. And I think that the point that Victoria made about using the likes of P&O, the likes of Woolworths as the standard by which businesses operate is akin to politicians, Labour politicians in particular in this respect, saying to the business community, well, you're all the same. And as you people know more than we do, the vast majority, I'm talking north of 90% of employers, do act very well towards their teams because they understand and appreciate that's how you get the best out of your business. It's how you do drive productivity, and it's how you actually end up with a successful business. So, as I say, I think what the Labour government have done here is throw the baby out with the bathwater and gone far too far on issues that, yes, did need to be addressed, but not in as vitriolic manner as it appears to be going through at the moment. So let's hope some changes are made. Just final word from you, Victoria. If people are a little concerned, they can get in touch and have a consultation with one of the HPC team, can't they?
Yeah, absolutely. And also just on what you mentioned before on the peopleHUB, that is an online community that is for HR professionals, business owners, managers, anybody that sort of deals with people on a day-to-day basis. And we will be supporting over the next couple of years over the Employment Right Bill as obviously that comes to fruition. So if they would like to join, they can apply to join that. It's free of charge. So obviously all downtown members are welcome.
Lovely. Okay, and we'll put a link to that as well, and obviously a link to our briefing note that we've issued to members of Parliament from the downtown and business perspective, and as I say, asking for some changes to be considered to those proposed legislative amendments. So thanks to Claire, thanks for Victoria for joining us in the Downtown Den today. We'll be back again soon, I'm sure, with another business owner, business leader who will be talking hopefully about things that are a little bit more positive. But we do appreciate your expertise and hope to see you all again soon. Thanks for listening.
Thank you.